Hello, I'm attorney Brad Micklin. I'm the managing member of the Micklin Law Firm, which is a law firm concentrated in divorce, custody, and family law issues, and located in Nutley, New Jersey. I'm making this video as a series I put together where I list the top 10 questions that I am often asked in a consultation. I give them to my clients before we meet so that I can get the basics out of the way, and when we sit down can really address the specific important issues. So I'm hoping these questions will help you if you either are meeting with me in the future or any attorney, or even if it's just to give you some basic information about how child support will work in court. So the first question I always get is, how much is this going to cost me? And that's impossible to know. Our firm does offer sliding scale approaches to our hourly rates and flat fees in certain cases. But absent that, if either we're not able to accommodate that or the firm that you're working with doesn't offer those, the cost of your case is going to vary depending on the complexity of the issues. And child support is not often that complicated, but it can be. The difficulty in the relationship between the parties and how well they communicate or don't communicate, and how promptly the court brings you into court and how long they make you stay. Those factors will greatly influence the cost. The second one is, how long will this case last? Child support case lasts anywhere from, after the filing, anywhere from say 2 to 4 months on average. Third most common question is, how many times will I have to go to court? Usually a child support case will be resolved with one court appearance. That will be the argument on the application, where the judge has oral argument and listens to the parties about what they put in the papers, but you will more often than not get the actual decision that very same day. Fourth question is, what are the factors for child support? The child support in New Jersey is calculated by the child support guidelines, which is an income-based approach that takes both parents' income and computes a payment amount that the non-custodial parent makes to the custodial parent. Now, this payment amount will be adjusted depending on how many overnights the non-custodial parent has, the cost of health insurance and who's paying it, the cost of daycare will be factored in if there is such an expense, and sometimes if there's special reoccurring medical or extracurricular needs that need to be addressed, they will also be factored into that. Next question, number 5, is, will I have to pay for college? And that's a complicated issue. The law basically says if you're married, we can't make you pay for college, or we can't make you send your children to college. But if you get divorced, the court does have authority. So they make it a very rigorous test to order college. There's a case, Newberg versus Arico, that has I think it's a 14-point test the court is supposed to consider when making this determination. But ultimately, all these questions are going to come down to whether or not the court believes the parents would have sent their child to college if they were an intact family, or if they would have remained an intact family. So all the issues around that in the Newberg case will all be dedicated to that type of determination. Number 6 is, when will child support end? Now, this is being made in 2017, the laws were recently amended where it's presumed to automatically terminate at 19, and the paying parent doesn't need to file any applications to do so. It can be terminated before that or after that if there are reasons to suggest that the child either has already moved beyond the need for parental support or continues to need parental support. The factors that will usually determine that, if the child is in the armed forces, living on his or her own, or any other factor that suggests the child has moved beyond the need for parental support, support will be terminated. In the event that the court determines that the child has not moved beyond that need, child support will continue. And in some limited, but some cases, child support never ends because the child has an ongoing need for support. Number 7, the question is, what if I lose my job or the other parent loses his or her job? That person will need to file a motion to modify child support. The court will normally require you wait 2 or 3 months because the loss of your occupation or your job needs to be more than temporary. And the court doesn't consider 1 or 2 months to be a longer than temporary or possibly permanent position. So after a few months, you can file to modify support. You would have to show a material and substantial change of circumstances, and that you have not been able, through diligent efforts, to obtain comparable employment or income levels. Number 8 is, how many times can the other parent bring me back to court? That, unfortunately, there's very few reasons a court is allowed to limit somebody's access to family court. So unfortunately, they could bring you back almost any time they feel like it. If the court does believe that the person is abusing the court process repeatedly, They do have some sanction abilities like awarding legal fees or possibly even changing custody, but there's very little they can do to prohibit them from filing, even repeatedly filing. Number 9 is, what do I do and what do I have to show if I do lose my job? I need to modify my child support. Like I said before, you're going to have to show a material and substantial change of circumstances and that it is not a permanent, or it's not a temporary one. You're going to need to show that you made diligent efforts to obtain comparable comparable employment, and that you simply aren't able to. The court may then order what's called a plenary hearing, which is a full but short trial to determine the issues. In some cases, you actually have to exchange financial documents, like you might in a divorce case if you happen to have gone through one. You might have to produce tax returns, bank statements, credit card statements, and show the actual lifestyle and prove that you aren't living the same way that you were before and that you cannot obtain comparable income levels. The court still has the ability to impute your income, which means they can still inflate your income back to where it used to be if they don't believe that you've made a diligent effort to obtain comparable employment. And lastly, will the court consider my expenses when calculating child support? Unfortunately, no. Usually they do not. The child support guidelines that I indicated before is presumed to be correct, and it's an income-based approach. It does not consider the expenses. Now, the parties, as well as the court, do have the ability to deviate from the guidelines, although they're presumed to be correct. You can deviate if there's just cause or if it's believed to be in the child's best interest. So you can then look at expenses. Commonly, if it's not by agreement by the parents, because parents can do it a little more easily, I think, than a judge actually can. If a court's going to consider expenses, it's usually going to be because there's some kind of significant aberration in the circumstances, like one parent has no rent expense because they're living at home, or they inherited a significant sum of money, so their expenses are reduced greatly because they have a house that they got for free, or something significant. Conversely, also, if expenses are significantly higher because the child has special needs, or even the parents have a special need, the courts do have the right to look to expenses and deviate from child support, but it is uncommon because the guidelines presume that they are correct. I hope this information helps you if you have a child support issue. If you need more information on this topic, you can go to our website, which is micklinlawgroup.com. It's MICKLIN lawgroup.com. The first page will have downloads that are ebooks that you can use. There's a video consultation room that has short questions and answers to address a lot of common questions. There's a video archive page where I upload a monthly webinar series I do, where I dive much more deeply into legal issues in family and divorce matters. All this information is free. You don't have to give me an email address. You don't have to fill out any kind of form. You just click on the media that you want to download, and it's there for you. You can watch as many as you want. You can forward to anybody who you think might benefit from the information. It's just there to help you. If you need any more information that's not on our website, you can call us at 973-562-0100. Thank you.